Hello, welcome everybody to this Zacco seminar about Unitary patent and unified patent court. My name is Michael Byström and I'm the director for international business within Zacco. And I know I've met a lot of people who has signed up for this webinar, so that feels really good. And I will shortly flip slides so you can see the agenda for today. And some practical things. You will be all muted to this webinar, but there is a chat forum, so in the chat you can write questions, and then at the end we will have a Q&A question session. So we hope to be able to follow up and take care of questions at the end. And if there are questions we don't have time for, we could also follow up on an individual aspect after the presentation, of course. So if you just write your name also in the chat, we know who to follow up more specifically with. And I also agree that we will send out a copy of the presentation afterwards, so you will have the slides. I think it could be useful. There is a lot of comprehensive material. So this is what we're going to talk about in more details. I will do a very short introduction, and then my colleague Nils Köster will talk about Unified Patent Court, and my colleague Corina Brink will talk more about details about UPC and different strategies and very much important things. And hopefully then I will sum up with some offerings and how we can assist you and your clients further on, so to say. And then at the end we will summarize everything. So the next slide is about Zacco. So I will actually skip that because I know everybody that is actually on this presentation knows very, very much about Zacco. So we'll just move on to the Unitary patent. So the thing with the European patent, well, it's completely granted under the European Patent Office, exactly as it has been, following the rules and guidance of the European Patent Convention. And then you have to request from the proprietor of the patent that you would like to have unitary effect, and that can only be done when you have went through the complete procedures within the EPO and the application is ready for grant. So I will show this slide. So what is important to remember about Unitary patent is that procedure is exactly the same. We file the European patent application. It goes through all the filing formalities. We have a search. We have the substantive examination, and then hopefully we'll have a grant of the European patent. Then when we have the grant of the European patent, then there are different routes to take. I mean, typically we will proceed and validate the patent today in the different states that we would like to have the patent validated in. Now there will be an option to request within 1 month a unitary effect. So this is the way that the unitary patent actually works. So up to grant, same procedure as every year, James. And then, when we have this possibility to request the unitary patent, then it will proceed and take unitary effect in all the different territories of the participating member states. So what about the date? Well, I think it was quite funny, so I have to keep this timeline. We started with this and we thought that it would be in place sort of in September this year, but as you have known, it's been postponed, and all just last week it was added an additional 2 months. But what is important to know, and that's also why we felt it really urgent to have this presentation before 1st of January, is that you can actually file early request for unitary effect and delay in issuing a decision to grant the European patent, even though the sunrise period have not started. because the sunrise period will not start until 1st March. It was originated recently to have started 1st of January, but now it will be delayed. And then the European Patent Court will take into effect 1st of June. So this is the timeline, and as of today, we are quite confident that this timeline will apply. So European Union, I wanted to show this mostly as information to have with you. I know it's not one country, Europe, so there's a lot of different countries. And in order to get the overall map when it comes to UPC, I think this could be good to have the understanding about EU. So there are a lot of European countries, and I have named them separately so you can see them. Then we also have a Schengen area, which is an agreement with a common border within EU so that we can trade and so on. So this is the overall map of the European Union. And when we map it with different situation when it comes to UPC, I just want to highlight some things, and it could be worth noting that there's some states who have not signed the European Patent Court agreement. As of today, Spain, Poland and Croatia has not signed. I know there have been discussions that maybe they will, was it Poland that might sign? I think Niels will touch base on this more in details when it comes to his presentation. And Germany have not ratified. It will do that 4 months before the Unified Patent Court will enter into force. So it will probably be before 1st of February this time. And then, of course, we have all states members of the European Patent Convention, but non-EU members. We have UK, for instance. We have Norway, Switzerland, and so on. So their countries are in the blue in the map. But I think it's a good idea so you have the overall view of the entire situation of the European Union and the United Patent Court. So the Unified Patent Court is a court that will be common to the contracting member states, and it will be part of the judicial system. So it's important to know that the European patents that will enter will have unitary effect within this Unified Patent Court. So within this Unified Patent Court, it will be a different separate court system compared to the national courts. And it will be not possible to have double patenting within the UPC and national courts. I think we will have time to maybe follow up on that a little bit in the end as well regarding double patenting, but I just want to mention that. And this was a really short introduction of the Unified Patent Court, up to the Unified Patent Court, and now I will leave to Niels to take over and elaborate further about the Unified Patent Court.
Good afternoon, everyone. Yes, I want to give you an introduction in the Unified Patent Court, to the Unified Patent Court. We are really looking forward to this coming into force. We've been waiting for it for a very long time, and now a very new court system will be up and running soon. I want to discuss with you briefly the structure of this new court, the basic aspects of the jurisdiction, and the main principles of court proceedings and the timeline. The court is supposed to be very quick and very much specialized about patent litigation. So I think it's good to know what we are facing here. In the end, I will briefly touch upon costs, and at the end, maybe answer the question whether the court will be a success or not. So let's look at the structure. It's quite simple. There's a court of first instance and there's a court of appeal. And with the court of appeal, it stays that simple. There will be one centralized court of appeal in Luxembourg. It will have multinational panels, 2 in the beginning, and there will be 3 legal judges and 2 technical judges who will decide upon appeals. The court of first instance is a bit more complex because it is supposed to have local divisions in almost every member state of the Unified Patent Court agreement. These local divisions will have 3 legal judges, and upon request, 1 technical judge can join these panels that hear the patent cases. Aside from these local divisions, we will also have 2 central divisions, 1 in Paris and 1 in Munich. And there's 1 specialty. There's also 1 regional division for Sweden and the Baltic states. These countries decided to have 1 common court and not to have 1 each, so they can join forces to do that. What we have to keep in mind is that all these divisions in the different countries, they all together are the court of first instance, so they belong together. And with all these different countries being 1 court, I'd like to explain a bit about the jurisdiction. In the map that you see here, all the green dots are actually places where a local division is placed, or at least the courthouse is. And now if we start proceedings, the question is, which court do we have to choose? Where can we file an action? And as it comes to local divisions, most importantly, you can always file an action at the place where the defendant has its seat. I think this is quite common in international law. And secondly, you can also file your civil action at the place where the infringement takes place. I think this is a most relevant reason where there is jurisdiction. Can you still see my screen?
Yes.
Okay. Because the place of infringement is already in a place where the possible infringer is offering the infringing goods. So if there's an offer on the internet and it's also directed to a specific country, for example, Sweden, Germany, France, then this would usually already be enough to have jurisdiction in that country. Besides these local divisions, there's also the central division, and this will have jurisdiction in default. So if you don't find a local division where you can turn to, you can always turn to the central division. And they are also responsible for independent invalidity actions, and when the defendant is from a state outside the member states. So let's discuss briefly the main principles of the court proceedings so that we understand how the court will work. We have to consider that it will be a front-loaded court proceeding, which means that all the facts and the evidence must be presented in the beginning, in a written procedure, actually. So in the writs that you file with the court, you must present all the facts and all the evidence. If you don't do that in the written procedure in the beginning, it might be too late. you might not be heard with further arguments at a later stage. After the written procedure, there will be an interlocutory proceeding, which is supposed to prepare the oral proceeding. During this proceeding, the judge rapporteur will prepare the oral proceeding together with the parties. There might be already a call with the parties involved to discuss what is necessary for the oral proceeding. And I assume at this point in time that the judges may already give a certain indication how they view the pleadings of the party, whether they need to introduce more evidence or arguments to the court to be successful. And after the call with the parties, there might be a further time limit to maybe file one more writ with the court, and then there will be the oral proceeding, and it's supposed to be within 1 day actually. To make this possible, the judges have comprehensive authority. They can ask the parties to concentrate their pleadings to certain facts. For example, the court might introduce a case and already explain where the problems of the case are, and then ask the parties to only discuss these aspects of the case that the court deems to be not clear yet. This altogether is accompanied by a regime of very strict deadlines, and these deadlines are already mentioned in the rules of procedure. I want to go with you through one common first instance proceeding, how the timeline could be on the next slide. So the written proceeding might be conducted within 5 months, and it's actually the idea to be able to conduct a first instance written proceeding within about 5 months. It all starts with the filing of the statement of grounds by the claimant. The rules of procedure actually call the plaintiff claimant. I think it's a different word than when you know it, but this is how the rules of procedure call the plaintiff. When the defendant is served with the statement of grounds, he has 3 months to respond and to file a response to the statement of claims. Already within the first months, however, the defendant will have to address formal aspects of the case. If the claimant, for example, is of the opinion that the division has no jurisdiction for this case, then they have to mention this already within a 1 month deadline. After the statement of the response to the statement of claims is filed, there will be 1 month deadline for the claimant to respond and a further 1 month deadline for the defendant, and then the written proceeding is already over. Then the interlocutory proceeding can theoretically start already after 5 to 6 months. And since this is mostly about preparing the case, the judge rapporteur having a call with the parties and maybe granting one more further possibility to file a writ, it is very much likely that this can be done within, I don't know, like three months. And the oral proceeding, if it doesn't take more than one day, then it's, in my view, very much likely that court proceedings first instance can be conducted within 1 year. The timeline gets a bit longer if a revocation, a counteraction for revocation is filed as well, but it's supposed to extend the procedure only by 2 months. So let's have a look at the court fees and recoverable costs. The court fees depend on the proceedings that take place. If you file an invalidity proceeding with the court, there's a fixed fee of court fees of 20,000 euro, and the claimant has to advance these fees in the very beginning. if there is an infringement proceeding, the court costs are calculated by a fixed fee and by a variable fee. There will always be a fixed fee of 11,000, and if the value of the case has a certain amount, a further variable fee will be added to this fixed fee. Just as an example, if the value of the case is about 4 million, then there will be a variable fee of 26,000. So the court costs will be 37,000 in total. And these need to be advanced by the claimant in the beginning of proceedings. There's also the possibility to recover costs by the winning party. The idea of court proceedings is that the losing party has to bear the costs of proceedings, of the court costs and also the winning party's lawyer's costs. However, since we all know that lawyers' costs are hard to calculate and they can be high, there's a ceiling for recoverable costs. And the ceiling also depends on the value of the case. If the value of the case is, for example, 4 million, then the recoverable costs for attorney's fees is 400,000 euro. And now the winning party will not automatically receive 400,000 euro from the losing party. The winning party has to explain why these costs were reasonable. And then the court will make a decision on the reasonable costs, and the losing party will have to reimburse. The decision on these costs can be appealed as well if the losing party thinks that they are not fair. So let's have a look on the question whether this court will be a success. Will it be relevant for us? And I very much think that it will be a success because the judges that are taking part in the system that have been employed by the UPC are highly qualified senior judges. Most of them have a background as national judges and even as national patent judges. When the UPC was built, I heard from the German judges at least that most of the experienced German patent judges applied to become judges at the UPC. And this is actually what we see. The best national patent judges were elected to become patent judges in the UPC. In the beginning, they will work half-time. A lot of them will work half-time as national patent judges and as judges at the UPC. So we will have the most competent judges sitting in the UPC. What is good is that the procedural law of the UPC is tailored to patent proceedings, and it's tailored to be a fast proceeding. This will make the decisions swift and good as well, I think. And compared to the present situation, the UPC will cover a much wider jurisdiction. You don't have to go to court in all the national countries. You don't have to go to France and then to Germany and then to Sweden with more or less the same patent. You can have a decision in one court in a very short time. Now, one really relevant aspect of the UPC, I think, is also the question of enforcement. It is good to have a court system where you can litigate European patents and unitary patents, but how do you enforce them? And there, a decision was made to not build up a new enforcement system, but one decided that the judgments, the decisions of the UPC can be enforced in all the countries just like national judgments. So nothing changes at that front. If I look at the UPC from a German perspective, and presently about 60% of litigation, patent litigation is taking place in Germany, then I'm quite confident about this court. 4 out of 15 local divisions will be placed in Germany, and they will be and 2 German legal judges will be in that court. There will be 1 more judge from a different country joining the panels that decide upon the cases, but there will be 2 very experienced German judges who hear the cases. Moreover, the procedural law is not too different from the present German one. If you think of aspects like a front-loaded proceeding, a fast proceeding, and a very short oral proceeding. So I assume that the judges will know their way around and will make good and swift decisions. And if we look at all this, we have to remember that this UPC will have exclusive jurisdictions in the end. It will have exclusive jurisdiction for the unitary patents, but also for all the common European patents as we know them already, as long as they are validated in one of the member states of the Unified Court Agreement. There's one exception. There will be a transition period of about 7 years in which one can opt out from this court system. It will be possible to decide that that a certain patent shall not take part in the UPC. And how to decide whether to opt out or not, my colleague Corina will discuss in the next session.
Can I check that you can all see my slides?
Yes.
Good. Okay. Right. Well, my name is Corina Brink. I'm a European patent attorney and UK patent attorney, and I work for Zacco UK, which is part of the Zacco group, and we support clients all over Europe. I'm going to talk today about using the UPC from a practical perspective, and hopefully this will work and move things down. As we've heard from Niels, we've got a new court system, and that presents lots of opportunities, and there are some risks, and also, you know, some rewards, I think, that people need to think about that the new regime presents. So on the risk side, if you go for the unitary effect, for example, it's all for nothing. You could lose your unitary patent in a lot of different countries, but you could also, you know, have the reward of just having a much simpler internal maintenance regime. You know, you've got one patent to review in lots of different countries, and that's, you know, quite beneficial in simplifying sometimes things. And also, if you have classical national validations, you can use the UPC to litigate in multiple different countries. And whilst there is a risk there, I think it's important to remember that certainly for the unitary patent, the European Patent Office has actually reduced that risk slightly. They've altered their processes, and there'll be a new top-up search just prior to grant, just to do an additional check for possible issues such as prior national rights. So you've actually got, you know, and the EPO, the risk will be the same whether you take the unitary effect or not. What changes in the new regime if you participate in the Unified Patent Court system is the impact of that decision, because the UPC will effectively, with one decision, revoke, as we've heard from Niels, your patent family in all participating member states if it's a classically validated European patent. And if you have a unitary patent, it will cause the unitary patent to be terminated. It's also a new system, although we've got very experienced judges and they're being very well trained. There isn't any, you know, UPC case law. People are uncertain of some of the processes, so there's a little bit more uncertainty about the outcomes. And as you've also seen from Niels, those timelines are quite fast-paced. There's a benefit from that. You'll get an early decision, so that reduces uncertainty. But at the same time, that could place a lot of stress on your in-house teams. And if you haven't prepared by, working out, to be honest, now really in advance, how you're going to escalate any incoming UPC patent litigation, I think people will be potentially caught on the back foot, even if there are, pre-action protocols follows. When it actually kicks off, it will be very fast paced. But the Unitary patent and the UPC offer lots of rewards as well. This can range from, as I've said, you'll have just one renewal fee for your Unitary patent, so you've got a long-term reduction administration. Downside to that is you keep it or lose it, of course, everywhere. But it has got this broad territory, and that could actually be beneficial in some situations where otherwise you might have to think about cross-border infringement issues and things like that. And of course, as it has such a broad value, and as you can license a Unitary patent, for example, individually in different territories, you've potentially got a huge increase in your patent portfolio value, and your stakeholders and shareholders may appreciate that. And there's also a perception that there's more confidence in the technology being innovative, although, as I've said, with regards, in fact, the risk of a patent being invalid is the same. It's the impact of the decision really that changes in the UPC. So how can you use the new regime to your advantage? Well, there could be, as I've said, new markets, and you could increase licensing revenue by taking the Unitary effect. You may be able to optimize your portfolio management, and you may want to reconsider your filing strategy if you're going to take the Unitary effect. Another filing strategy, of course, is to avoid the regime altogether and to consider filing national patents, and that raises the issue of double patenting. National patents and, for example, taking a Unitary patent might be quite an interesting option. Some countries may allow you to do that with double patenting, others won't. And if you want advice on that, I suggest you reach out to us because it will be quite sort of country specific. But there's also an opportunity here to sort of be, if you want to be more aggressive towards your competitors' patent portfolios, if you monitor their opt-out status for strategic opportunities, because central revocation through the UPC is again a very powerful and intimidating choice, and that may provide you with some useful negotiation if you start an action before the UPC to revoke a competitor's patent, whether they've initiated litigation against you first or not. And I think consequently to this, there could easily be some changes in the way that you experience incoming litigation by your competitors. So from a patent attorney perspective, wherever are you in the world, if you have clients who have European patents, I think the advice that they really need to hear is to understand the new regime is, are they likely to be litigating in Europe, or are they already in litigation elsewhere in the world and are thinking of extending it to Europe? Could they want to litigate more in the UPC regime, helping them to understand what the risks and rewards are? Are they likely to have action taken against them by competitors in the UPC regime? And really, if that is a risk, preparing them for that fast pace, because by the time information has flowed from the other party through the court document management system into various people's dockets and out to the client, they have to have their teams set up and their processes for escalating and responding, and that will happen, but that pace is quite brutal, and I think preparation will really help people manage that situation if it happens. When it comes to opting out, I think the thing to bear in mind are that opt-out strategies are likely to evolve over time as we get more familiar with the new regime. During the sunrise and transitional period, you can opt out granted patents. You can actually opt out pending patent applications. The thing to bear in mind if you opt out an application, of course, is if it's opted out, you can't take the Unitary effect on grant. And after the end of the transitional period, you can't opt out. The jurisdiction of the UPC will be exclusive. Having said that, it's currently 7 years, but there is provision in the UPC agreement for it possibly being extending. I wouldn't rely on it either way, but I think that's something to bear in mind. So key strategies really are, and they can be boiled down to 3 options. Do nothing, but you have to really understand the risks and rewards and ensure your clients do. Opt out. which is only available, as I've said, during the transitional period, which sort of maintains the status quo, but there are some issues to consider here. If you do want to opt out and you've got co-owners, they've all got to agree to opt out. You may want to check if you've got contractual obligations to either use the regime or not to use the regime with your licensees. And there are obviously issues for any licensees, normally exclusive licensees with litigation rights, to bear in mind. They may contractually oblige you to opt out. You never know until you've checked your agreements. And obviously, if you do opt out, you can't take the unitary effect if that's an application you've opted out. And also you have to opt out the entire family. No pick and mix for participating member states. However, you can take the unitary effect for some states, and then obviously in states like the UK and Norway, which aren't participating, or any of the other states that aren't participating, they are automatically effectively opted out. So the other issue is that you can opt out and opt back in, only available during the transition period, but there's no urgency unless you are concerned about risks to opt out during the sunrise period. You can do it after the new regime comes into play. So you can make a measured decision if you think that, realistically, there aren't the resources available to do an entire portfolio review by the new start of the sunrise period, which is in March. You can do it during the sunrise period for some quite important patents, and then review the rest and decide whether you want to opt them out or let them stay in the new regime after the agreement comes into play, but only as long as you do that within the first 7 years. So what does it actually mean if you opt out? So if you don't do anything, the situation will be after the sunrise period ends and the start of the new regime kicks off in June, as the current date is. There'll be dual jurisdiction between national courts and UPC courts. So if you wanted to, you can use the national courts, but people will still be able to attack your patent using the UPC if they wanted to. So it depends on whether it's the same action, considered to be the same action or not. So that's something to bear in mind. If you opt out, then effectively you just maintain the current status quo. And if you opt out and opt back in again, you can opt out and then you might decide, for example, that you want to use the UPC for some litigation, in which case you might opt back in again. And again, you also might want to monitor your competitors to see whether they opt anything back in again, because that's quite a good flag if they first opted out, that they might be considering some litigation activity. The influencers for your opt-out decision, and we've covered some of these already in advance, so I'm going to skim over these quickly, but it's basically this way of preventing competitors or defendants from filing a cost-efficient single revocation action effective against all national parts of the European patent validated in a UPC member state. It wouldn't, of course, affect if they did that a patent that you may have validated in Norway or the UK, for example, because they aren't participating in the new Unified Patent Court regime. If you opt out, however, the rest of your patents, so all of your family out, you'll avoid this legal uncertainty. You avoid the fast pace and time limits, and you can withdraw that opt out unless you've got the jurisdiction seized nationally. If you don't opt out and you stay with dual jurisdiction, so you remain within the competency of the Unified Patent Court to hear your any legal actions involving your European patents or unitary patents, then you'll have the availability of pan-European injunctions. I mean, this is a huge benefit for anybody who's considering litigation in multiple European states, not just because of the simplified processes, but because of the way that you can just set up a single litigation team and everything is being handled by one group, and it will hugely reduce the impact on internal processes as well, because your internal teams will be able to just communicate with one team of attorneys, and that should make, I think, the whole process, although some of the court fees are rather high, as we've heard from Niels, very effective and attractive. It also You know, it gives you the opportunity, if you get involved early, to influence perhaps the case law, to establish some of those precedents on issues that might be relevant if you're in the sort of game of trying to seek to establish case law. And it does avoid, you know, the risk that you could get some national jurisdiction being seized effectively by somebody, perhaps filing some action like it could be an action for invalidity, or an action for non-infringement, or so a declaration of non-infringement in a national court. But as I've said, you do have to think about certain other influences. Co-owners, you've got to have all co-owners agree. That could be easily challenged. And I think it's a really good thing if you can keep some evidence, and maybe even send that to your patent attorneys when you're saying, we'd like to opt out. Here's evidence that we've all agreed, and everybody just sort of, makes it very clear then that they were in agreement for that opt-out decision. Licensees, maybe it's time, if you haven't done it, and I know that quite a few active companies who are very active in licensing have already revised their agreements, but what will be the default decision? Opting out, not opting out? What will be the process if perhaps you have an exclusive licensee who wants to litigate nationally? If you haven't opted out, how are you going to, are you going to trigger the opt-out? How will that be handled? Will you need, if you've got multiple licensees, their consent for the opt-out? If you're also licensing applications when they come up to grant, what will be the unitary, the way to decide on whether the unitary effect should be taken or not? How will you manage dissent between different licensees? Who will be responsible for authorising any registration of any opt-out? It's quite common in some licensing agreements to defer administration to the licensee. But not necessarily the renewal fees, I have to say, but these are things that need to be all considered. So if we move quickly on, again, the advantages, well, cost primarily. You could get protection currently in 17 participating member states. It could easily go up to 24 in the next 6 months, although there are some issues with some countries. And there are some, I think, some problems in, I think it's Ireland at the moment, and maybe Hungary. I don't need to check that. But then you could have an increase in your asset value as well due to the broader geographic coverage. The opportunities are for a pan-European injunction, and also cost-efficient enforcement by a single infringement action. If you stick with the current national validations, you opt out, and so you don't take the unitary effect. Well, you need to think you can reduce your portfolio holding over time as those renewal fees get more expensive. You could just, for example, if you originally validated in the UK, France and Germany, drop your French and UK validations and just retain your German validation. You can't do that with the unitary patent. It's all or nothing. And we've also mentioned, if you take the classical route and you opt out, your competitors would not be able to use the unified patent court. So what do you maybe need to do, or maybe need to advise your clients about? Filing strategies. They should be revisiting those. Opt-outs, will they be policy driven or case by case, and how will they manage their status? Will they want to use? Zacco has a lovely tool called IP View that will let clients and agents look at the status, but that is something again to think about. How are they going to, they may need to revise their internal case management systems if they don't use one of the commercial ones to sort of monitor and know whether a family has been opted out or not. They need to decide whether they might want to take the unitary effect or not, which may be policy driven or case by case, and also think about their maintenance regimes, because if you're going to keep or lose a patent everywhere, you might want to do a more thorough review before you drop it. The other thing that I think is quite interesting at this stage is to think about how there are some economic opportunities here with the new UPC regime. How will stakeholders value a patent portfolio? Because in some instances it's to do with territory, and of course you'll get a huge uplift if you normally validate in just 4 countries, and now you're validating effectively in 17 with a single unitary patent. But on the downside, if people just count patents, then they might think, oh well, it's all or nothing, they're more risk-based, then it may not have the uplift that you might otherwise hope for. And it's really about understanding how people feel comfortable with embracing the new regime. I think that the issue is, as I've said, it's not about the risk of participating in the Unified Patent Court. It's about the impact. The risk is probably the same, but the impact and therefore the consequential risk on portfolio value is potentially high. And there are lots of other little nuances that we won't really have time to go into here, such as, for example, the order of co-applicants when you're naming applicants in a parent application. If you've got more than one, will actually decide things like national law. Why is that important? Well, it affects how the Unified Patent Court for unitary patents, for example, might treat the application as an item of property, and that can influence things like inventor rights to it, assignments, and even licensing revenue if you haven't got contractually agreed terms that indicate perhaps something different to national law. And finally, the filing strategies. Do think about issues such as double patenting. In some countries, if you do go via the PCT route, for example, into France, you have to go PCT Europe into France. So you might want to think about national convention filings for certain states if you are uncertain whether you want to participate even after 7 years in the new Unified Patent Court regime. That's been quite a quick taster. I'm hoping there may be some questions. Jenny, Michael, have we got any questions that have come in?
No, not so far, Karina.
Not so far. I can just sort of round up a little bit. Really good talks from Corina and Nils here as well, and we'll have some time to also go through some Q&A. I just wanted to briefly mention that what we do also is that we have helped a lot of our clients, domestic clients, with workshops, and this we also would like to offer to our preferred agents around the globe as well. So I mean, I will not go into detail, you will have the chat, but we can be a support to you if you need regarding a discussion with your clients in any way, provide support and discussions, so and we have an UPC expert group where Corina and Nils is a member of, and we have that in several different aspects, of course. So just in case, feel free to reach out to your contact person at Zacco, and we will be happy to assist you with all these kind of different discussions that could be of use. And also I would like to show you, we have decided on cost for taking action and assisting you when it's going to be opt-out, depending on the number of granted patents, so there will be a cost because we need to do this, as you know, and of course it could be a discussion with a UPC that you have to opt out. Why you should have the opt-out shouldn't be the other way around when we have decided to go into one system, and now we are if we want to go into the other one, then we should have taken action. But now the EPU has chosen to do it this way, so we need to take actions. Yeah, and with that short summary, I will see if we have received some questions from you guys out there. And while Jenny may be checking out a little bit, I'll
do that. Yeah. No, Michael, there is no question.
Yeah. So I have a really good question, I think, for Corina maybe then. What do I do to get a unitary patent? When we have received the 71.3 communication in practice. So exactly, what do we do?
Well, basically, you reach out to the patent attorney firm who are representing you, and you indicate to them that you'd like to take the unitary effect. You must do this very quickly, though, because you only have 1 month. They will have 1 month from the mention of grant to take the unitary effect, and that is the important thing. So really, if you think you might want to do internal discussions, start the process early, because we cannot extend that deadline. It's it's many deadlines can be. We will not have things like the plus 10 days going forward or anything like that. So please let us have your instructions, and that's all you need to do. You just let us know that you want to take the unitary effect, and if we're representing you in Europe, that's as simple as that.
Perfect. And Niels, I also was thinking about the court. Let's say now we are past summer and UPC is actually in force, and one of our clients or the patent actually is challenged. So how can we help in that aspect, Niels, from Zacco as an attorneys?
Yes, a good question. We have a dedicated UPC team actually, and it consists of patent attorneys and also legal attorneys, attorneys at law, that are specializing in the UPC. And so we are able to support and represent clients in court and care for court proceedings, as for the claimants, also for the defendants. But we are also able to support if the client has a litigator that he's working with. We gladly also assist these litigators in procuring all the information from the client, giving technical analysis and information, or give legal opinions to support other teams here. And what I'd like to mention is that this UPC is very real, and the UPC will hear court cases not only regarding the unitary patent, the EP with unitary effect, but also all the EPs that are out there already now. All the patents that have been granted in the past will become subject to the jurisdictions of the UPC. So this is very real, and we need to make decisions now whether we want to litigate them in the UPC. The opt-out possibilities refer only to the EP patents, not to the unitary patent. This will always be litigated in the unitary unified patent court, and revocation proceedings will be there as well.
Thank you. Another aspect that I'm thinking about when we are talking about this, you really need to start thinking about this, because it's really here. I know that it's been discussion for many years about the UP and UPC court now, and
yes,
one really needs to be alert, because the time frames are short. As Corina said, I mean, there's 1 month time frame to proceed and request unitary patent, and also, as Niels has discussed a lot, when and if it happens that you are challenged at the court, or if you are considering challenging a competitor, you really need to be prepared, because it will absorb a lot of resources on the applicant hand to be there. Right, Niels? You need to be sort of really prepared.
Yes, and you might ask yourself why we have this delay again. Why does it start 2 months later than thought in the beginning? And the reason actually is IT issues. The court is up and running, but they are presently have last IT issues. So this is only technical, and as soon as these IT issues are solved, the court will go live. And the ratification of Germany is just everything is ready, and all parties agreed that Germany will deposit the ratification in the moment the court is ready. So everyone is waiting for IT systems to work, and then this court will start.
Yeah.
Perfect. Thank you for that, Niels. I think we have at least addressed a lot of topics. I know, Karina, I think we have like 4, 5 minutes left of the scheduled time. So no further questions surfaced, I guess, Jenny?
No, that's right.
So
what I can share as well is I had talked with judges that will become judges in the UPC, and they are very eager for the system. They are really looking forward to it, and they really want to make it work, and they want to work together across borders as well with the different jurisdictions. And so I think that we will see judges that are very much motivated to present a good court system for the participants.
And I think that's the other thing actually that may not be apparent to many patent owners, is that many of the divisions will actually have the option, or by default will use English as the language of proceedings, which of course hugely simplifies things. And that's often because you'll have judges from different countries participating, and then obviously there's some it reduces the amount of translation that may be needed. So for clients who maybe have taken their English as the language of proceedings, I think the UPC could make it very easy and a lot simpler, in fact, to litigate in some states. So. And for anybody who's interested, exactly, rather than London, it's probably going to be Milan, so you can look forward to the shopping.
And I just put on the last slide where you can find the contact information to me and Nils and Karina if you have any thoughts and you would like to reach out. So feel free to contact us. And as I said, we will distribute this presentation to you who have registered. So you will have that, and as always, we'll be here to support you in the best possible way. So feel free to reach out, and I think we are actually on time, so that feels really good that we managed to comprehend this in 1 hour, and we hope that we'll be able to provide you with some insights and thoughts, and you will be able to take this with you when talking to your clients as well, of course. Well, yeah, thank you from me here in Stockholm, and hope to connect with all of you again